Like in any other injury case in California, two elements are necessary in order to make a slip and fall case worth pursuing for you, the victim of that type of incident, and for any attorney who will be representing you. And these two elements are liability and serious enough injury. If one element is missing, then that type of case is probably not worth pursuing. Let's talk about the second element first. Let's talk about injury. Any recovery in an injury case, whether it's by way of settlement or judgment in court, is based on your damages, your past and future medical treatment, your past and future wage loss, and your past and future pain and suffering, if any. If you suffered a serious injury when you slipped and fell, such as bone fracture, broken foot, dislocated knee, maybe you landed on your head or shoulder when you fell, breaking other parts of your body, you will require expensive and extensive medical treatment. You will probably be unable to work and do other things for a while. You may even need a surgery and time to recover from surgery with all kinds of pain and discomfort, which is likely to last for weeks, months, or even years. So clearly, in this type of case, you have evidence of significant enough damages. On the other hand, if your injury is limited to a bruise or a few bruises or a mild sprain, which is going to resolve in a few weeks at most, then this case isn't going to be worth pursuing because the damages are just not there. They're not sufficient enough. Of course, most cases fall somewhere in between, and then it becomes a judgment call where an experienced attorney should be able to advise you whether your specific case is worth pursuing and why. Now, let's talk about liability. In order to have a case, it's not enough to simply slip and fall and have an injury. You have to show that it was due to the negligence of the party who is in charge of handling the area where the floor is located, where you slipped and fell. There are different ways to show evidence of such negligence. Maybe there was a spill of water or oil where you fell that could and should have been cleaned, but wasn't for much longer than it would have been reasonable. Maybe the stairs on which you slipped and fell were known to be worn out, and the landlord in charge of those stairs was notified earlier that those stairs needed repair, and he didn't do anything for months. Maybe one of the employees of the business in charge of the floor where you slipped and fell left something on that floor and created that dangerous condition. Those are common types of evidence of negligence. However, if you don't know why you slipped and fell, or maybe you slipped and fell due to your own inattention, or maybe due to a condition that was created immediately before the incident, even maybe by you, then proving negligence is going to be a challenge, if not impossible. So there would be no case to pursue, no matter what the injuries are. It is known that in many cases, if the injury is very, very serious, but evidence of liability is very, very weak, the other side, the defendants, will often still pay to just make that case go away because the risk of losing is still there. Again, in these types of cases, this is going to be a judgment call on the part of the right attorney who can help you advise whether your case is worth pursuing in light of the entire picture, in light of all the circumstances. But again, generally, you need both liability for negligence and significant enough injury in order to make a slip and fall case worth pursuing. Thank you.